Justice Prathiba Singh, dignitaries on the dais, eminent judges of the Supreme Court and the High Courts, experts from the legal arena, invited guests. It's an honor that I'm standing before you to participate in this very important day for Prathiba and also for all stakeholders in the patent and copyright world. If I can start by saying, in India's long history dealing with patents and copyrights and so on, the last 10 years have seen quite a few milestones. And in each one of them, which I'll very briefly recount, in each one of them, Justice Prathiba Singh, as justice or much more even before it, has had a very significant role to play. So 2015, the current government under Prime Minister Modi set up a think tank to look at IPR in India. That is the intellectual property right, and how do we handle it? Is there a policy? What is the kind of policy we want? So a think tank was formed, and Justice Prathiba Singh, then not justice yet, was a very active member. She contributed immensely to it. 2016 was when the policy was framed, and post that, a very significant milestone was when, in April of 2021, the Intellectual Property Appellate Board, which existed till then, was abolished. And all pending cases before the IPAB, the board, was transferred to the respective high courts. But the high courts were, as it is, faced with a backlog of cases, and those cases related to intellectual property, however important, however very critical for the development of the country, and however much the government placed emphasis on them, had to become a part of this backlog. And in the meanwhile, the Parliamentary Standing Committee started noticing that this backlog is not going to be healthy at all, and had taken a very strong position that high courts may just not be able to cope with the backlog, and therefore an appellate tribunal, which was just only a recent or few years back, was abolished. The standing committee took a position that we should go back to appointing the appellate board again. But the abolition happened as a result of the Supreme Court's verdict. But then, post taking that position, the Parliamentary Committee also wanted to review the intellectual property related matters, with just then the policy having been framed in the country. It had called a lot of stakeholders, and many who were seriously involved in the process of making the policy itself, and also looking at how high courts were taking up their responsibility, appeared before the standing committee. And post the review, much to all our surprise, and pleasant surprise at that, the standing committee took a favorable position that indeed the high courts are doing all right and that they should continue doing it, only because, and I singularly put this credit to Justice Prathiba Singh and to the Delhi High Court, led by its Chief Justice, for having the Chief Justice of Delhi High Court had given a big support, and with the intellectual and the footwork of Justice Prathiba Singh, the Delhi High Court set up a IP bench. And the way in which the bench rapidly handled issues related to the intellectual property matters actually gave the confidence to the Parliamentary Standing Committee. And I reiterate, for a Parliamentary Standing Committee to change its position and say, nope, it can back again be with the High Court where it is now, and went further to say every High Court should create an IP bench. So singular contribution of the Delhi High Court, the Chief Justice and Justice Prathiba Singh, to show that where there is a will, there is a way, and Delhi High Court overcame all the difficulties that it faced to set up this bench, and that bench actually proved that it was efficient in clearing up the backlog, streamlined the way it was being handled, and gave confidence that it doesn't matter that there is a backlog, but if it is a dedicated bench, things can move. And especially with the interest in commercial matters, and also in India, the policy going towards greater innovations, a greater patent, greater copyright, greater trademark registrations within India. So I begin on that note. If she has today succeeded in giving us a fantastic tome which can be referred to when you're talking on matters related to patent laws, not just in India, but anywhere in the world, it is because she has gone through it as a leading advocate and subsequently also understood the process through which a bench can become expeditious in these matters. A little was said about how India is looking at handling IPR. I would take a few minutes to explain a few things on that because we are talking about this subject with such interest today. In India, of course, IPR laws, the policy, are all being given a certain kind of push because in research and development, in patenting and innovations which are happening in very big scale in India now, because the environment is being made conducive for that purpose. In that, we keep balancing the protection aspect for those who innovate, those who seek the patent, those who get the patent, together with looking at the commercial propositions with which they can be of use for our society. So the IPR laws, we are trying to make them as a facilitator, booster, and not certainly a barrier in the process of R&D. We've taken quite a few steps, and I singularly thank Honorable Prime Minister for this particular policy, which after a lot of consultation has come up in 2016. A few things were taken up soon after that. 8 different items, all of whom have something to do with intellectual property, have all been brought together, meaning they are under one umbrella. As a result, you're not running from pillar to post. Everything to do with the policy management on intellectual property rights are now under one framework, be it patents, trademark, industrial designs, copyrights, geographical indications, semiconductor integrated circuit layout design, trade secrets, and also plant varieties. So all 8 of them are broadly under the same framework, and the legislative framework is TRIPS compliant. It's necessarily for safeguarding IPR, and we certainly, as I said earlier, are trying to balance between patent protection as much as development concerns which they have to address. Very many steps have been taken in order to help greater patenting and also registering of patents. We have reduced the fee for startups and MSMEs and also for education institutions, and we are fast-tracking examinations and making sure specific applicant groups are treated with a bit more care and with efficiency. We've also established National Intellectual Property Awards to recognize individuals and organizations that have created as well as commercialized IP. There is a particular scheme which the government has brought out called a scheme for pedagogy and research in IPRs for holistic education and academia. Under this, 37 IPR chairs have been established by Government of India, and this promotes IPR study and research, and also for commercialization of IP. Technology innovation support centers have also been set up. They are set up in central universities and state universities, and since 2020, that is within 3 full years, 12 established such centers of TISC, Technology Innovation and Support Centers, have been established, and they have filed 734 patents within the last 3 years, conducted 1,752 IP awareness programs, and commercialized over 100 patents. You are aware that there is a cell for IPR promotion and management. We call it in short CPAM. That was also created in 2016. CPAM has been instrumental in raising IPR awareness through tailored resource materials and in programs in various educational institutions and industry bodies. Till today, they've conducted 1,200 events and 3,000 plus academic institutions. Our government has also signed, I think in 2019 itself, government has approved the accession to 3 important agreements. The Nice Agreement concerning international classification of goods and services for purposes of registration of marks. Vienna Agreement establishing the international classification of the figurative elements of marks. Locarno Agreement establishing an international classification for industrial design. We've approved accession of India into these agreements. So that actually immediately opens up a lot of avenue for us to align ourselves in many of the copyright and IP related matters with what's developing globally. Traditional knowledge digital library has also been established. This was established even in 2001, but today it has the advantage of so many different databases, all of which are available for them. The traditional knowledge digital library was restricted to 14 patent offices only. But in 2022, we have approved expanding access to various stakeholders like businesses, research institutions, and also educators on paid subscription model. All these have actually helped us progress rapidly in various different dimensions of IP, about which some parts of which the previous speakers have elaborated. But the biggest advantage which an Indian author like Prathiba gives us in India is that she's contextualized India's IPR trajectory with what is happening globally. And it was really music to my ears when I heard an eminent speaker before me identify that Prathiba's contribution singularly stands out for how she has framed the Indian IPR ecosystem, government policy, and the way in which our courts are handling IPR related matters vis-a-vis what's developing outside, but bringing in that necessary Indian element. I'm owning it up as Indian, but essentially an element which brings the important element in commercializing patents, that is, looking at how it's going to help the society. And unless a country which is like India, diverse in its developmental perspectives and goals, thinks about those aspects, you're going to miss out and probably lose out on only commercializing patents. it is necessary to bring it down to the earth and tie it to the roots, which is necessarily reflected by the diversity of India's development being spread across this vast country. I think this is a very big contribution that Justice Prathiba Singh has made, not just for jurisprudence, but also for India's contribution on a very contemporary topic which is developing in such rapidity because of technology getting into all our lives. And this book, I think, is going to be for several hundred years as the core reference material on intellectual property. I wish Prathiba all the very best. She's got the right mix of a practicing judicial officer, a thinking mind in a very legal sense in that way, but I think ultimately a good teacher in that she makes things simple and easy to read, all of which is in this 2-volume book. I wish her all the very best, and thank you very much for inviting me today here.